Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Within a few moments of the first time I saw Judge Toal in the Murdaugh case and listened to her rules with respect to how the hearing was going to be conducted, I could have told you at that point exactly how this was going to come out, and I would have been right, because I would have said she's going to find that there is no prejudice to Murdaugh, especially in view of the overwhelming evidence that's in the file. Now, I don't know if you had an opportunity to watch this live or not. I happened to be busy with other things, so I didn't get to see it live. But when I did get to see it, I was impressed by the quality of her analysis. So let me explain a little bit about what's going on. First of all, I think there are two serious findings out of that hearing. The first one is that you can't trust anything Becky Hill says. When an appellate judge sitting as a trial judge says that a witness is not credible, that is the kindest and nicest way of saying she didn't tell the truth.
The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books.
And of course, the other big thing that came out of this is that she reached the right legal conclusion on what the burden was.
My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the Clerk of Court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influence the juror to vote to convict defendant Murdaugh.
The defense has the burden to show actual prejudice. Not some imaginary prejudice, woulda, coulda, shoulda, but rather real prejudice that this actually impacted the verdict. In essence, that it changed the juror's mind. Now, one of the reasons that courts are really reluctant to delve into the jury process to find out what motivated a jury to reach a particular verdict, one of the reasons they don't want to do that in an official way, it's okay if researchers do that, right? But it isn't okay for a trial court judge to call in everybody and say, okay, I want to know why you guys found this guy guilty. The reason you don't do that is because what happens in the jury room, much like what happens in Las Vegas, stays in the jury room. And that's the way the rule has to be if you want to have actual jury procedures. If the jury has to worry about their decision-making process being second-guessed at a later point in time, then it really isn't a jury at all. It's just an advisory panel. So I think that that's the rule, and the rule that we have is a good rule, and the reason we have it is to protect the jury process. So Judge Toal wasn't going to go into why did you make the decision that you did. She was going to ask each one of these jurors, and apparently she did, that, did anything Becky Hill said to you influence your verdict?
Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors.
So in a jury room, what happens, and many of you may have seen the movie 12 Angry Men, which essentially dramatically depicts a jury process that goes from pretty well stacked toward conviction to acquittal on the basis of one juror in there arguing for what he truly believed based on the evidence. And that is an interesting case because, it's an interesting movie because it depicts what could happen in an actual jury room. And in that jury room, the jurors, if that one juror wasn't quite convinced that he was absolutely guilty, the jurors pressured her into saying, look, this is the way it's going to be. So she felt pressure. But at the end of the day, she stood up and she said, yes, that's my verdict. She had an opportunity after they'd rendered the verdict, when the court polled the jury, to say, nope, I've thought about it and it's not my verdict. So she went along with it, and the only time she really changed it was when she got a bunch of, rabid dog lawyers pounding on her door saying, how dare you convict my client? And that's the problem with having jurors accessed after a trial. There is always a potential that somebody is going to be bullied into saying something that might be possibly true, it might be possibly false, and there really is no way to tell. That's why when the jury comes back and is polled, that's the end of the deal. If there is any doubt in the juror's mind at that point, they have to say, okay, I have some doubts. Maybe this isn't my verdict. Maybe we need to go back into that jury room. That is what the whole process is designed to allow jurors to do. That's why they poll jurors at the end. Now, I think Judge Toal handled it very, very well. In fact, let's listen to a little bit of what she said.
The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter.
I think Judge Toal is an excellent judge, and I think she did exactly what she should have done in this case. She applied her 20 years of experience as a lawyer and her 35 years as an appellate bench judge and trial judge and said, you know what, this is really unique. And as a result of it being unique, there isn't really anything that's on all fours with it. So the only thing we have to go by is what our Supreme Court has said in this case. And although the Rimmer case is out there and has not been completely overruled, it has been distinguished and it's been abrogated, and the abrogation has been recognized in case law. And as a result of that, the standard that was announced there, presumptively prejudicial, has been retrenched from and is no longer the standard. And in South Carolina, the standard is very clearly actual prejudice. Now, Harpootlian and Griffin knew that going in. They argued for a different standard, and I can't fault them for that, okay? This is something that happens routinely, particularly in places like the Ninth Circuit. For example, even though the Bruin decision is very clearly suggestive that you should not have magazine bans and that Armalite rifles should not be banned, unfortunately, the Ninth Circuit still thinks they're right, and they refuse to apply the Supreme Court's precedent. And until the Supreme Court slaps them down, or until they are held accountable for essentially ignoring Supreme Court precedent, they're going to continue to do that. So lawyers do get up and say, but what about Rimmer, right? What about that case? You know, that's the one we really like. It's okay to do that, but the judge made the right call here. And that's what I have for you today. Thank you so much for watching. Today, if you have the opportunity, perhaps you could donate food to a food pantry, or maybe go volunteer at a homeless shelter for a couple of hours. There are a lot of things we can do with our words in talking to people that sometimes change lives. And you shouldn't sort of diminish that in your thoughts. Well, there's nothing I can do. I mean, what could I say to a homeless guy that might convince him to, turn his life around? Well, maybe you could tell him about other people who have. And that is a gift unto itself. Everybody has different gifts. Use your gifts to make the world a better place. In an upcoming video, I will go over what I think the chances are on appeal. So, that's it. Have a great day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.